So as we progress through the investigative principles textbook, we've talked about different crimes, how to investigate, techniques for investigation, but it all culminates, investigations all culminate in some sort of legal action. Either the prosecutor, well, the prosecutor is going to review the case. And bear in mind, as we discuss the legal process today, this is not specific to North Carolina. Because this isn't BLET, and we're not going to the police academy, we're not learning Johnston County law, we're not even necessarily learning North Carolina law. We're going to speak in generalities of multiple jurisdictions, but a general process. So the process specifically, if you were to go into the criminal justice world in Johnston County, it may be slightly different, but we're going to talk about the major principles. Once the investigation is complete, we have a couple different options. Well, one I know we've discussed. What is the primary way in which an offender gets into the criminal justice system? Right, unless they commit a crime, they have to commit a crime or be suspected of a crime. And then at some point, how are they invited to court? At some point, it can be a subpoena, but there's one the most common way.
Be arrested.
There you go. Be arrested. The most common way for somebody to be cordially invited into our criminal justice system, be arrested. So as investigators, as budding investigators, once your investigation is complete, there are a couple options to get them into custody. The first option is, if the threshold is met for the person to be arrested, that person can go, in many jurisdictions, can just go be arrested. The investigator or a representative, another officer within that agency, can go arrest that offender. That's especially true if the investigation is very quick. If they're still at scene when the crime occurs, standing next to, it doesn't have to be a dead body. These aren't lengthy investigations. If the investigation, if it's a theft investigation, and you go there and say, hey, this person just stole my purse, and 3 witnesses say, yeah, I saw them steal the purse. Okay, that was your investigation. That's no less of an investigation. It's just less complicated. The investigation is complete. The person is there. The person is arrested. That's how they're going to be entered into the criminal justice system. However, that's not always going to occur. Secondarily, the investigation is complete, and we figure out who did it. We're no longer at scene. It's a month later. If the investigation is complete and we still have those same 3 witnesses who said, yeah, this person did it, and the victim says, this person stole my purse, we identify the person, is there any difference between going and arresting them at scene or a month later? Is there any less evidence? No. The only difference being felony versus misdemeanor. Bear in mind, you can have all of the evidence in many jurisdictions. You can have all of the evidence you want of a misdemeanor, but if that misdemeanor did not occur in the presence of a law enforcement officer, then no arrest can be made on that misdemeanor. Felonies are different. Grand theft versus petty theft. We're going to need something else to arrest a misdemeanor or to cause a misdemeanor to be arrested. Any ideas? If we can't go and just willy-nilly run out and arrest a misdemeanor, we'll call it petty theft. They stole a $200 purse. They're gone. Here's the story. Walked into a store, stole a $200 purse, walked out, they're gone. Police are called, they respond, there's video. The officer says, I know that guy. That is Joey Schmuckatelli. I know him. The pictures, you take remember we talked about photo lineups, put together a photo lineup, put together a 6-pack, take it to the store clerk and say, hey, do you recognize the person who stole that purse? And they pick number 2. Number 2 is Joey Schmuckatelli. So the officer recognized them, the clerk identified them. There's very little doubt. Does that meet the threshold of probable cause, do you think? That we have enough evidence to support the fact that there's a fair probability that Joey Schmuckatelli committed this crime? I would say so. However, stealing a purse of $200 value in most jurisdictions is a misdemeanor. And I've just said, and didn't occur in the presence of an officer. Officer wasn't even there when it happened. What are our options? How does Joey end up in jail? Or a warrant, yes. We have two types of warrants, A warrants and B warrants. Arrest warrants and bench warrants. Bench warrants are when you don't show up to court when you were supposed to. You get a bench warrant. Arrest warrants are when the judge said, when you bring the case to the judge, and the judge says, yes, you can go arrest them. However, there's somebody you got to talk to first before the judge, usually. The DA, the prosecutor. Prosecutor has to decide whether or not they're going to prosecute that case at all. You don't bring it directly to the judge because there has to be a case number. The prosecutor has to say, yes, we're gonna try this case. We're gonna prosecute this person. If the prosecutor is not going to prosecute, you can't go to the judge and get a warrant. So the entire package, we're gonna bring that, everything we've talked about this semester, all the tools, all the documentation we talked about this semester is all going to be brought to the prosecutor's office. In larger jurisdictions, prosecuting agencies have specialized assignments. Some people are assigned to, we're going to talk about preliminary hearings shortly, and they only do preliminary hearings. Some people, and then within there only do jury trials. And then they're specialized, just like law enforcement officers. Some people specialize in sex investigations. Some people specialize in auto theft. Some people specialize in murder. That's what they do. They're just homicide detectives, sex detectives. Same thing in larger prosecuting agencies. You have special victims sections where all they prosecute is sexual assault crimes. But in this case, the misdemeanor, you would go to, the reason I bring that up is because some deputy district attorneys is the term that their actual title, some deputy district attorneys will be assigned to what is called the filing team. They're filing deputies. And all they do all day is talk to the investigators, the detectives that come in and bring case packets all day long. You sit in line, you sign in at the DA's office, you wait for your turn as an investigator, and when it's your turn to be called, you go into the filing deputy's office and say, here's my case. Do you guys want to prosecute? That's the entire point of that meeting. And they get through them. Some are more complicated than others. Some are homicides. Some are misdemeanor first steps. The method with which they review the case can be different. In the same way we discussed how, in the same way that we discussed that judges, when you present for a warrant, sometimes they want a story, sometimes they just want to read it. Same thing with filing deputies. Sometimes you're going to present the case, say, here's what I got. Or sometimes they're like, no, let me read it and make a decision. And they have essentially close to the final say as to whether or not that district attorney's office is going to file that case. If they say no, the investigator could be as excited about this case as they want. And it happens. I've been there and I presented cases as a detective and I go, this is a great case. I can't wait. And they read it and I say, we're good. We're not gonna file that. So what happens to my suspect when they say no thanks? We'll say they're out of custody. We'll still say the purse. I think I got the officer recognized them. The 6-pack, they served with the right person. They signed it. Everybody says it's him. I give it to the DA, the filing deputy, and the deputy goes, what's the rap sheet on this guy? Nothing? Nah, we're not gonna do it. What happens to Joey Schmuckatelli, who's not in custody? Nothing. It's their decision. The district attorney has the final say. One point, because I'm complaining just a little bit. In some jurisdictions, we have two prosecuting agencies, a district attorney and a city attorney. In general, in larger like cities like Los Angeles, the city attorney will do the prosecuting of misdemeanors and the district attorney will do the felonies. But for today, we're just going to talk about district attorneys in general terms. So yeah, you're right. Nothing. That's it. That's the end of the case. Now there are some appeals processes, and they're not necessarily legal appeal processes. They are processes that essentially boil down to, no, come on, man. This is a good case. Come on. It's a come on appeal. You're trying to appeal to them, like, come on, this is a good case. And if they still say no, you can ask to speak to the filing deputy supervisor. There's always it's a bureaucratic organization. There's always going to be a supervisor. And at some point, you're gonna, if you, maybe the supervisor will overrule and say, okay, yeah, you're right, that is a good case, we'll file that. But there is such a thing as prosecutorial discretion. And they're often immune from civil liability. So if that store who had the purse stolen can't necessarily always come back and sue the DA's office for not filing the case. Other times, I told you about times I've been married to a case. As you get more experience in the investigative world, that tends to fade, in my experience, I've seen. But it doesn't always go away. There are going to be times when you put a lot of work into a case and it looks like a slam dunk to you. But I've never been a prosecutor, so I don't know everything there is to know about trying a case, and they have tried cases, so they know that they don't necessarily want to file a case that isn't easily proven. Maybe they don't have the resources to lose cases, so they want to have a high batting average. Maybe they just can't afford to call a bunch of experts and pay for experts to come testify on a maybe. So they would rather just not file a case and only take the ones that they can win. Because what is the threshold to prove a criminal case to a jury? What do we need to prove it beyond?
Reasonable doubt.
The term reasonable doubt, yeah. Which is a very high threshold, which is a higher threshold than just to arrest somebody. Even if we have that first thief in custody, all that is needed for that is probable cause. And we said probable cause is defined as, is it fairly probable, is there a fair probability that that crime occurred and the person was involved in that crime? And even lower, just to detain them, if you remember. Just to detain somebody and not arrest them was reasonable suspicion. A set of articulable facts that would lead a reasonable person to believe that a crime has been committed, is being committed, or is about to be committed, and the person to be detained is in some way associated with that crime. Just somehow associated with a crime that hasn't even occurred yet. We can't arrest somebody for a crime that hasn't occurred yet, but we can, the government can detain for that and investigate. Higher than that is probable cause, higher than that is beyond a reasonable doubt. So that threshold is very high. You could be as married to that case and as sure that they did it, they're already in custody. Because the example I used was our purse thief was out of custody. Now, if our purse thief is in custody, that all those same steps have to take place. The investigation has to take place. The presentation to the district attorney, the prosecutor, has to take place. However, we have a very limited window. Anybody remember what the window is between the time of arrest and the time of arraignment?
48 hours.
48 hours. 48 court hours. Two court days. So in theory, that 48 hours. And you're on Friday, Saturday, Monday. So we'll talk about last week on Easter. This is a holiday, right? Good Friday was a holiday. So there's zero. So we had a holiday here. Courts aren't open on weekends. You're arrested. You're arrested here. 48 hours, 48 court hours, 2 court days is 1, 2. That's a rough time to get arrested for 48 hours. So 2 court days, oftentimes called 48 hours. But in general, if that happens on Tuesday, they're going to court on Thursday. That gives you 2 days to complete your entire investigation, no matter what, if they're in custody. If it's a lengthy investigation, sometimes 2 days isn't enough. There are many sexual assault crimes that take far more than 2 days to investigate. even if you know who did it. So we changed that out. Instead of being a first step, it's a sexual assault where the patrol officers get there and there's a complicated child abuse case. Some sort of, it's going to take a long time to investigate. We need evidence, we need analysis of the child, things like that. If you arrest, in this case, we'll say the father suspect. If you arrest the father suspect for a suspected crime of abusing that child, and it's going to take a long time. It's going to take weeks to get back all your analysis and evidence and reports. Crime occurred right here on Tuesday. Crime occurs on Tuesday, due in court on Thursday. You go, he's standing there, kid's there, the officers want to arrest, the investigator comes out, and you realize as the investigator, it's going to take a good 2 to 3 weeks to get all your analysis back from the labs and things. Otherwise, you have no evidence for this case. There's a good, you suspect the child is making statements that there's some sort of crime, that maybe the mother is making some statements, but there's really no proof until you get those lab results back. Those lab results are going to come back in 3 weeks. The officers say, looks like there's enough evidence. We have probable cause to arrest. We have all these statements, and you make that arrest here. What's going to happen here when you still don't have those lab results? You're going to present that case to the DA and say, okay, here's my case. And they're going to say, where's the evidence? Oh, it's going to be like 3 weeks. Well, we got 48 hours. 48 hours to file that case. That person can end up getting let go. So what's our alternative?
Then go and come back with it.
Bingo. You don't have to make that arrest at the time. We could put the child in a safe place. We could take care of the situation, make sure everybody's safe. But there's nothing that says that arrest has to be made right then, just because we're notified. Investigator can now take 3 weeks, 4 weeks, 5. Now you're not even rushing for the 3 weeks and getting the day you get it back. 3, 4, 5 weeks. You put your case together, then present it to the DA's office. The DA says, if the DA looks at it and says, yeah, that was good. You got your statements that you had back here. Now it's 3 weeks later, you got all your lab results. They all come back, show the evidence of a crime being occurred. Crime has occurred. Then let's file this case. Then we can do exactly what we talked about before, and then you take that case to the judge and ask for a warrant. Otherwise, it'll go to a judge eventually, and a warrant will be issued. But you could go to the judge immediately and rest on it. So that's the 2 ways. You can file for a warrant, or you can file for somebody in custody already. If they're in custody, if it's a crime that was short, they're in custody, and you're within your 48 hours, you present to the DA says, yes, let's file it. They're already in custody. Now we have our next step. The same next step is going to occur whether or not you later go pick them up on a warrant or they're in custody. Eventually, we're all going to get to this same next step, and that is your first appearance. First appearance in court. If you've taken the court procedures class or you're just aware, what types of things do you think need to happen in that first appearance or an arraignment, sometimes called an arraignment?
You read the charges.
Read the charges. That's a huge part of it.
Be advised of their rights too.
They could be, there are some rights they're advised of, and there are some rights that go into play after that, like Miranda style rights. There's a different case law than Miranda that are applied after arraignment. So, and then the bail is addressed, because not every time somebody is arrested for a crime is that what means that's what is filed. We'll go back to the purse thief. In this case, the purse thief stole a $5,000 purse. Same scenario, walked in the store, stole a $5,000 purse, walked out, case is filed, Joey Schmuckatelli did it, Joey Schmuckatelli's in custody, boom. At the time Joey was caught there, a $5,000 per felony or misdemeanor in most jurisdictions. Yeah, usually a felony, $5,000 is above most thresholds. Felony, grand theft. Joey's going to jail for a felony. However, we present this case to the DA. The DA looks at Joey's rap sheet and says, this is like the first time Joey's ever done anything wrong. There's really no reason to throw the book at Joey. Yeah, we'll file. I mean, you can't go around stealing $5,000 purses without consequence. But there's really no reason to make this guy a felon and take away his right to vote, put him in prison, take his right to own a firearm for life. He made one mistake in his life. Granted, he made a mistake, needs to be punished. We're going to file petty theft. That's a prosecutor's discretion. They're allowed to do that. Well, the bail is going to be a lot higher for grand theft than it is for petty theft. Hypothetically, we're looking at maybe a $20,000 bail for grand theft and maybe a $1,000 bail for petty theft. So that needs to be addressed at the hearing. Hey, you thought you were in jail, or you were in jail for a felony. We're going to read the charges. The charges are, you're being charged with petty theft of store property. Your bail is $1,000. Because if the judge didn't read that to Joey, who's going to tell him? Joey slipped when he was booked into jail, says grand theft. His bracelet says grand theft or felony. He was in the felony housing section of the jail. So those charges have been downgraded, and so is the bail. So when somebody needs to tell Joey, hey, you don't need $20,000 anymore to get out. It's only going to cost you $1,000 to get out. Also, don't worry, it's not that big a deal anymore. That's part of the arraignment. It does go two ways, though. You could be arrested for a lesser crime, and in that meantime, while you wait for arraignment, more charges can be tacked on. Or you could be arrested for grand theft of that purse, but further investigation revealed that Joey knew that he was going to steal that purse before he entered that structure. Is there another crime that sounds familiar? Entering a structure with the intent to commit a felony or theft? Burglary. So if there was evidence revealed, the investigation revealed that Joey had that intent before he went in there, he was arrested for grand theft. But now when he goes to the arraignment, by the way, you're being charged with grand theft, burglary. Maybe he fought with the store clerk at the time, and now it's going to be upgraded to a robbery. Just all the bracelet said and all the paperwork said was grand theft. If nobody tells Joey that these can be filed, all those charges can be filed at the same time. And that's part of presenting your case to the DA. So the arraignment reads the charges, advises of some rights, and addresses the bail. Bail can be deviated also at that time. Judge could even take, in theory, the judge could read, oh, bail is now only $1,000. You know what? It's only $1,000. I'm going to release you on your own recognizance. Come back, your court date is in 6 years. Judge has that discretion. That's the first appearance of the arraignment. And that is all as the investigation and an arrest is the method of entry to the criminal justice system. There's an alternate entry into that criminal justice system. And that is, I'm going to back up. We'll address that in a second. From the initial appearance, the arraignment. Now, that case, the prosecutor has to present that case to a judge, not a jury, to a judge, a very abbreviated version of that case, just to show the judge that there is enough evidence that it should go to a jury trial. Right now, all we've had is an investigation. A filing deputy has looked at the case, said yes, and filed the case, and that case has been read to the offender. But it hasn't come before a judge per se. The judge has read the charges, but hasn't reviewed. So, in order for a judge to make a determination of whether or not this case has enough merit to go to a jury trial or not, we need a hearing called a preliminary hearing. Sometimes we hear the term prelim. Some abbreviations here. So a preliminary hearing, you'll hear slang sometimes called a prelim. Other jurisdictions call it a PX for preliminary examination. those are just slangs. You probably won't see that on any tests. But a preliminary hearing, the whole rationale for it is, let's prove to the judge that this case has merit, and there's enough evidence for it to proceed to a jury trial. That there's enough probable cause. So that's going to be done. If probable cause is a lower threshold than beyond a reasonable doubt, there's no need for the prosecuting body, the DA or the deputy DA that's trying the case, to pull out all the stops and all the experts and go for a week and a half on this trial. Preliminary hearings are like 30 minutes, an hour. 20 minutes maybe if it's a quick case, it's a possession of narcotics case. If it's a little complicated, maybe might go a few hours, but it's not going more than a day really. And all it is you're calling a couple witnesses to the stand, as a prosecutor is calling a couple witnesses to the stand, saying what happened. The defense is going to cross-examine them, and then the judge is just going to say, okay, yes, it seems like there's enough here. We're going to proceed. I find that there is enough cause to proceed to a jury trial. And the term is being held to answer. If there's enough cause for this to go from prelim to jury trial, then that offender, that defendant now, is going to be held to answer. If not, charge is going to be dropped. And if those are the only charges pending, then that offender, that defendant is going to be released. If they're in custody. If they bailed out, then the trial is over. The vast majority of preliminary hearings, vast majority of prelims, held to answer. Like 90%, like almost. I've seen maybe 2 in my life that didn't. Not to say there aren't more that I didn't see, but 2, and I've been involved in many, many cases, and 2. The vast majority. Sometimes it's so overwhelming that the defense just doesn't even put on a defense. A lot of times, the defense will listen to the prosecuting witnesses, cross-examine the prosecuting witnesses, and then say, "We're not going to call any witnesses. We have no affirmative defense." But I don't think the prosecutor pled their case well. You'll see that very, very often. No witnesses from the defense, one or 2 witnesses from the prosecution. The defense will say, "Nope, we're not putting on any witnesses," but we still don't think they did their job. They didn't prove it. They have to make that motion. And almost every time denied. Motion denied to dismiss. Motion to dismiss denied. Held to answer. From there, the jury trial will be the next step. Now I'll take a step back to what I was about to mention. That is one way, the most common way to enter the criminal justice system. There is an alternative. I guess one's a music style. So there's a grunge way of doing this. So the alternate way of doing this is you don't have to tell, the defendant doesn't have to know they're under investigation at all. We can take that $5,000 purse fee. The officers get there and say, "Hey, I recognize that person in the video. That's Joey Schmuckatelli." Do a 6-pack. We do the photo lineup. Store clerk circles Joey's name. Boom. We don't necessarily have to go get that warrant right now. We say, why don't we go to a grand jury and present this case to a grand jury? Joey's out there. Joey's not hurting anybody. So go to a grand jury. 30 people are going to hear the evidence against Joey. They're going to sit there and hear the evidence behind closed doors in secret. The prosecutor's going to tell the story. The prosecutor's going to say, here's why we think Joey Schmuckatelli is guilty or should go to trial for grand theft. Here's a video of Joey stealing the purse. Here, I'm going to call the officer. Do you recognize that person? Yeah, that's Joey. I've arrested Joey 10 times. I know. I went to high school with Joey. That's Joey. And then they're going to call the store clerk. Were you working the day that person stolen? Yeah. Were you showing some pictures of 6 people? Yeah. Was one of them the person that stole the purse? Yeah. Did you circle it? Was that one right there? Yeah. Everything points to Joey. and they're gonna present that to the grand jury. Now, we never told Joey Schmuckatelli that he was under investigation, right? We never told him there was a grand jury being convened. How is Joey gonna tell his side of the story at the grand jury? Doesn't. Only one side of the story is told. Only the prosecutor's side of the story is told to the grand jury. How difficult do you think it is to prove to 30 people that somebody is suspected or probably guilty of a crime if you're only telling one side of the story? Not hard at all. It is very, very easy to get an indictment in a grand jury when you only tell one side of the story. There is no defense in general. Now, there's nothing that says that the prosecutor doesn't have to tell the person under investigation that they are, and you can, in theory, you could come and defend yourself, but you have to know what's happening. And in some cases, that occurs, but you don't have to. So there's a phrase out there that people say, you can indict a bread box. Just nothing. You can indict anybody because you're only telling one side of the story. Now, if the grand jury indicts, that's them saying, yes, this should go to a jury trial. There's enough evidence there. That is the same thing. That achieves the same process as that preliminary hearing where both sides were telling their side of the story. Then the person can now be arrested, the warrant can be issued, and we can go straight to jury trial, no preliminary hearing. What are your thoughts on the grand jury process? I'm curious to hear what you guys have said. I kind of gave you my take on it a little bit, but that more factual. What are your emotional thoughts on it?
It seems a little bit unfair. I mean, not unfair if it's like so much evidence against this person that they committed like a felony or something like that, but isn't it part of like due process where everybody should get to state their side of the story no matter kind of the trial? I feel like that's
It is definitely a unique situation for sure. And due process does occur because they're still going to get that jury trial. And so nobody's found guilty in a grand jury. But yeah, you're right. It does have that, it does kind of leave a lot of folks with a bad taste in their mouth. I would venture to say the vast majority, you now know more about the judicial or the criminal justice trial process than the vast majority of society. Society hears grand jury. I think we hear it on TV all the time. But I would venture to say, even myself in law enforcement for many years, because grand juries are so rare. I heard the term, but I heard it more on TV than I heard it in real life. I didn't know what it was. When I found out, when I actually experienced, I testified at a grand jury, and I was like, "You have got to be kidding me!" How? And then I started researching and learning more about it, and realized, oh, this is how our justice system works in this case. The vast majority of cases don't go to a grand jury. The vast majority of cases go to the first process I had, which would be in Mr. Reich's terminology more fair. But they're all going to going toward a jury trial at some point. Now bear in mind, not every case ends up with that jury trial. We said early on, around 95% of all cases never get to a jury trial. No more than 5% of these cases are going to actually have a trial. Our system would grind to a halt if we had more than 5% of our cases going to a jury trial. We just don't have enough juries, enough judges, enough prosecutors. We just don't have enough time in the court system to have more than 5% of the cases go to trial. We have to have a plea bargain. And through this entire process, outside, once the defendant is notified of the crime through arrest or through warrant, the plea bargain process can begin anytime. So from there, either way, we're going back to the jury trial, prelim or grand jury, regardless. Oh, the terminology for if the grand jury finds that there's enough cause to go to jury trial, we call that indictment, but spelled kind of weird, INDICT. Looks like indictment. However, if they say no, On the rare occasion that the jury trial or the grand jury hears a case and says, only here's one side and still says, I'm not feeling it. I don't think you got enough here. If they decide not to indict, that term is called no bill. So either way, we're heading towards jury trial. The plea bargaining process can occur at any time. There is no mandate for it, but most jurisdictions are going to try to plead just about every case because we don't have the logistical resources. We don't have the resources to go to jury trial for everything. However, we do, the jury trial does begin. Before that trial convenes, what do we need for a jury trial? We need a jury. So jury pools are going to be selected. Has anybody here ever been on a jury? I have not. Yeah. It can be. I've gotten or received several jury summons, but where I was receiving them in my jurisdiction, there's a box on your jury summons that gives some excuses, and one of those excuses are you a sworn law enforcement officer? If you are, you just check the box and send it back. You're dismissed immediately.
So is that only for only law enforcement or anybody like anyone who works in the department?
It's not a law, so it would depend on the jurisdiction. My jurisdiction was only for sworn law enforcement officers.
Okay.
But why specifically do you think that they didn't want law enforcement officers on the jury trial?
You might know who the person is.
Maybe.
Now they do, like when you go in there and you know the person is going to like.
Yeah, I know they question you.
Yeah, they just, and so you know that you're either.
Yeah, I used to intern as a media officer, they got some paralegal,
Mhm.
and there were like a lot of like, you question the whole jury, and the judge was like, all right, yeah, you can't. You're gone.
The term for a question at jury is a French term called voidire. You see that, like I'm not positive on spelling it, but it's like VOIRDIRE, voidire. It just means it's questioning. That terminology gets used a couple times in our court system. One for juries, voidire juries question, but also as witnesses. Witnesses usually testify to the facts of a case, what they saw. And all it's limited to, you'll hear an objection. Sometimes, maybe on TV, you've heard this. I object, the witness is speculating. You're not allowed to guess or give your opinion as a witness. You're only allowed to talk about what happened, what you saw, facts. However, that's not universal. There are witnesses that are allowed to give their opinion. Those witnesses are called experts. That's the legal term, expert. An expert witness is allowed to give their opinion based on what they know. This is what I think based on everything that I know about this case. But not everybody can do that. And in order to be deemed a witness, or excuse me, deemed an expert, you have to go through a voir dire process. You have to be questioned by the defense, and the defense has to stipulate, okay, yeah, that this person does know enough to be an expert. The legal threshold oftentimes in jurisdictions for being an expert witness is not that high, legally. Doesn't mean you want to beat the bare minimum of that threshold as a witness, but the legal threshold is not very high. Essentially, in order to be an expert witness, one has to know more than the general public about that topic. Are there any topics you guys are familiar with or seen even on TV about, like, there are expert witnesses in what? Has to be, there's topic specific. Could be forensics. Those who are taking forensics classes.
Yeah, like latent.
Yeah, you could be an expert in latent prints. And so it's my opinion based on my expertise and what's been presented to me that these two items are a match. Because it's not evidence yet. It's analyzed, and it's my opinion. Or bloodborne analysis, or serology, I should say, serology analysis. My experience as an expert witness came in narcotics. So, in general, if I arrest somebody, or if somebody is arrested, doesn't even have to be somebody I arrest. If somebody's arrested with a kilo of cocaine in their jacket pocket and $1,000 in 10s, 5s, and 1s in their other pocket, they're arrested. No other information No, didn't see any transactions. In fact, this person was arrested originally because there was a radio call of a fight. And when you got there, the officer saw this person punch another person. So they took him into custody, arrested him for that battery. And when they searched him, incident to arrest, the I in the spice chart, incident to arrest, they found a kilo of cocaine in one pocket and $1,000 in 10s, 5s, and 1s in the other pocket. Everybody in this classroom probably has a very similar opinion of what that person is doing with that cocaine. Is that person using 1,000? Is that person can use a kilo of cocaine tonight? Is that for personal use? Why not? Why don't we think that cocaine is for personal use? It's too much. It's a large amount. That's a good start. Why else?
A lot of cash on them.
A lot of cash. What does that mean to you?
You gotta have change or somewhat.
Could be change, or maybe there were 2 kilos before and he cut it up. Could be. What else?
I mean, selling it.
Sure. Makes it look like it's the other. So there are different crimes. Being in possession of cocaine is one crime. Being in possession of cocaine with the intent to sell is a completely different crime with a different bail, a different section, and a different exposure. However, in this story, nobody saw this gentleman sell. So how are we going to prove this case? We don't have facts per se. We have some facts. I shouldn't say we don't have facts. Can we absolutely prove that this person has sold to any one person? We have a witness that says, yes, he sold to me? No. All we think is that he had the intent to sell. We need an opinion. We need somebody to render an opinion that you all just rendered that says, yeah, there's just too much. No user is carrying around a kilo of cocaine. And on top of that, they're probably not carrying around $1,000, but if they were, it would be in like hundreds. But this guy had 10s, 5s, and 1s, which is pretty indicative of somebody who's either got change or has already sold $5 rocks already, a bunch of $5 rocks already. And you throw in some other, there's in his other pocket, he had a scale. A scale had like cocaine residue on it. Like that just tells like he's weighing out little, and then he had a bunch of little baggies in another pocket that they were full of little tiny amounts that were all evenly weighed. Those are all just different facts. Those are facts, but still we don't have any one person he sold to. So in order to prove that case, somebody's got to render an opinion. And that somebody is going to put all those facts together and say the totality of all of these things together says, it's my opinion, this person is not in possession of this cocaine for personal use. It's my opinion that they're in possession with the intent to sell. And that's why you need expert witnesses. That's my experience. I was an expert. And then in order to be deemed an expert, you have to go through that voir dire process. You have to be cross-examined by the, or voir dire, not necessarily cross-examined, by the defense attorney. The defense attorney is going to say, well, if you think you're a witness, prove it. What makes you, at that point, it was Officer Bell. And what makes you, Officer Bell, think you're an expert in narcotic sales? I said, well, I've made like 1,000. I've been involved in like 1,000 narcotics investigations. I've spoken to just a ton of narcotics users on what they do when they use. Most narcotics users use immediately. There's not a lot of folks that are going to the Costco of cocaine and buying a bunch in bulk because it's cheaper. Because they use it faster because they're addicted. Most people that have a large amount are involved in sales. Usually, especially in this neighborhood, a lot of folks, this is a very, this is Skid Row. It's a homeless neighborhood. Folks don't really have $1,000 in their pocket. They'd be in a hotel or a house or an apartment. And usually when people have $1,000 in their pocket, it's my experience from talking to all these folks that they have it in, the defendant told me that he just cashed his paycheck. Most places that cash checks don't give it to you in 10s, 5s, and 1s. That's my experience. So I put all that together, and he said that, and then most people just don't walk around with a scale in their back pocket, especially if they're going to have cocaine in the other pocket. It just tells me that I think he's selling. That's how it happened. So I skipped a little step there. All the factual portions would come during the preliminary hearing. The voir dire would be more things like why do you think you're an expert? Because I read all these journal articles. I've trained for this long. I've taken this class. I've made this many arrests. Those would be the voir dire process. And then rendering the expert opinion would come just a little bit later. But that expert opinion cannot come if the voir dire process is not successful. if you don't successfully prove that you are an expert, then you can't give your opinion. Then you're just speculating. So we go to the jury trial. Like you said, the jury trial will, we need to select the jury, they're questioned, and make sure that they are not biased, willing to render a fair verdict. And from there, the trial will start. The trial, do we know the order? Who gets to go first? Who gets to call witnesses first? Yeah, prosecution calls witnesses first. Defense always goes last. Defense always has the last word. That's part of the due process. Defense has the last word. The prosecutor's going to call their witnesses. Everybody they have. They're going to testify to. They're going to call the in our case, but Joey Schmucknelli, they're going to call the clerk, and they're going to question all about the day working. What time you saw Joey come in? Was there a security system? They're going to set the foundation for all the questions. They're going to call somebody who installed the security system. They're going to call the people that viewed the security system. They call the officer who recognized him. And then they call the investigator who put together the 6-pack. All that stuff, they're going to call those witnesses, but one at a time. Calling those witnesses. Then, so the first witness we'll say would be the cashier, the clerk at the store. They're going to set up the foundation. The prosecutor's going to ask all the questions they want to ask. That's called direct examination. The asking of questions, the legal term is examination. So the direct examination from the prosecutor. Then we have cross-examination from the defense. The defense can ask anything they want in general about that case to show that either they're not a credible witness or to bring out information that supports the defendant. Now, both sides have asked their questions. We have the prosecutor ask their questions, the direct examination, and we have the cross-examination. If something comes up in that cross-examination that the prosecutor wants to clean up or clear up, now it seems a little confusing, the prosecutor can now redirect. However, they are limited in their scope of their redirect to only the things that were asked in that cross-examination. They can't say, oh, I totally forgot to ask this. Now you had your chance to direct. But you can use redirect to clean things up, but not to bring up new material. Then after the prosecutor clears up what they think they needed to be clear up, then we recross. The recross is limited to only those topics, and the topics just get smaller. And then in theory, after they're done with cleaning that little piece up, you can do a redirect to clean up just a little bit more, but it gets smaller and smaller and smaller. The scope of what's questioned gets smaller and smaller and smaller. So in theory, or in general, you have direct, cross, you can have a redirect and a recross. But it's going to go in that order. Every witness has that opportunity. The definition of direct is not associated with the prosecutor, it's associated with who called that witness. Because when the defense comes up and starts calling their witnesses, they're going to do direct examination of their own witness. Whoever calls the witness is going to do direct examination. So don't associate direct with prosecutors. Whoever calls the witness, so the defense calls their witnesses when it's their turn, when the prosecution calls other witnesses and they rest, now it's the defense's turn. They're going to start calling witnesses, direct examination, and then the prosecutor is going to do a cross examination. We can still do redirect and recross. That is the evidence phase of the trial. The jury is going to deliberate. If the jury does come back with a verdict of not guilty, because like we've said previously, or I've said previously, at least in other classes, that people in general don't get found innocent in trials. Innocence is usually not a finding. You may see it on the news, you might see it written down in articles, oh, they were found innocent. But were they? Or were they found not guilty? There's some exceptions, there are some factual innocence findings, but in general, folks are found guilty or not guilty. Not guilty doesn't mean you didn't do it, it just means you weren't found guilty. If they are found not guilty, done. The jury has reached a verdict. What happens to our offender if they're found not guilty? Yeah. Same thing that happened way back at the beginning when they decided not to file the case. That example, same result. Just took a lot longer to get there. No consequences. However, if they're found guilty, then we move on to the penalty phase. We have the guilt phase or the evidence phase, then we have the penalty phase. Penalty phase can be almost like it can be in significant trials, can be almost like a whole new trial. A lot of times for homicide cases where if it's a capital case, they're gonna have a a penalty case to decide whether or not the person should receive life in prison or capital punishment. That could be an entire mini trial in and of itself. We don't necessarily have to have a penalty phase of every trial if it's a cut and dry minor case. Found guilty, goes to the judge for sentencing. Now, in reality, that sentencing is probably not going to occur right away. It's not found guilty, okay, you got 10 years. It's going to be found guilty, go back into custody, and we'll see you back here in 6 weeks for your sentencing, or sometime later. Any questions on what we talked about thus far?